Five.
Should I switch between slides? So I just click is there?
Yep.
Oh yeah, that works.
Điều khoản tăng được rồi đấy. Okay.
Yeah.
Okay. Let me start.
Everybody, how are you? Thanks for joining me today. Taking time out of your busy schedules to come. From a law firm not too far from here, just down the block, called Dialogue Professional Corporation. It's myself and Mr. Xiao Yudai. We practice real estate, civil litigation, corporate law. And what I want to talk to you about today, because you're all agents, is residential real estate litigation. And so, covering that, I just want to talk about some common real estate litigation disputes and the system and how it works. And why I want to talk to you about the civil litigation system, because as you know, this is the biggest, buying or selling a house is the biggest transaction for most people's lives. That is their most valuable asset, Greater Toronto area. And so because of that, when things go wrong, the hitch, it results in a dispute. And so if the dispute cannot be resolved, it'll end up in court. And so as real estate agents, it's very common that if there's a real estate dispute, the agent will become involved in some capacity. Either your company will be sued or you will be asked to be a witness to speak to certain matters about the transaction. So in Ontario, for real estate disputes, there's only two courts that somebody can go to try to resolve an issue. So some common real estate disputes that I want to talk about are property defect cases, failure to close the transaction, and how to, if you want to protect your commission, if somebody doesn't pay your commission for whatever reason, what action you can take, and negligence claims. So the first place that you can take a real estate dispute is small claims court. So small claims court is has exclusive jurisdiction over all civil disputes in Ontario for amounts equaling $25,000 or less. The small claims court has no other powers. They cannot make any court orders for anything other than the payment of money. So if somebody has a dispute about, the boundary or anything like that, they can't go to small claims court. The only thing real estate disputes that can go to small claims court are things like this: unpaid real estate commissions under $25,000, undisclosed property defect claims. And by that I mean when the seller was aware of a significant defect in the property, either a structural issue or something else affecting the value of the property, and they did not disclose it to the buyer. So the buyer feels that the seller misrepresented the purchase, and they could sue them for the damages. And the damages would be what it would take to fix that problem. So, for example, if there was a structural issue, they could sue for whatever they require to fix that structural issue. Now, small claims court only goes up to $25,000, so it's only claims under $25,000. It also deals with commonly disputes relating to chattels and fixtures. So if somebody was expecting that there would be a chattel or a fixture to go along with the sale of the house, and they did not receive it, either through some misunderstanding or bad faith on the part of the seller, they can go to small claims court to obtain compensation for the value of that chattel or fixture that was contracted for. And again, also for misrepresentation, so issues about the seller's representations about the property. And I also encourage you that if there's any questions that you have at any time while I'm going through it, feel free to ask it, and we'll also deal with questions at the end as well. Okay, for small claims court, so let's say, for example, you were not paid your commission as a result of the fault of the seller, and you were owed $20,000, and you were not paid that $20,000. So what do you do? So what you do first is you file. Of course, you would try to resolve it out of court. We always encourage that. If that doesn't work, you would have to file your claim. So that's the initial court documents. You attach all of the documents that entitle you to the commission. You file your claim with the court. You have to personally serve it on the person, meaning that you hire a process server and they give it directly to the defendant, the defendant being the person you're suing. After that, the person has an opportunity to defend the claim. If they defend the claim, the court sets it for a settlement conference. So a settlement conference, that'll happen about 3 months or so after you start your claim. That's a brief 30, 45-minute meeting with a small claims court judge where they'll take a look at what's been filed and they'll say, okay, here's what I think about the case. What can we do to fix it? What can we do to resolve it? So they'll encourage the parties to settle, and that's where the majority of small claims court cases end up being resolved. Most people do not want to go on to a trial, so they decide, okay, I'll accept less than maybe what I'm owed, or it's less than what I think I deserve, but I want to get this over with. If, however, somebody's being unreasonable and they're not offering anything, or the legal issues are too complicated, it can end up in a trial. And so a small claims court trial is just like any trial. You've probably seen it on TV. It's the witnesses come up, they get questioned, they get cross-examined, and the evidence is presented. And after all that, the lawyers make arguments, or in small claims court, you can hire a paralegal. The paralegal makes the argument, and the judge makes their decision. After the decision is made, the court makes an order for the payment of the money. Now, there's some pros and cons to going to small claims court, even to the point where, let's say your claim is for $30,000, you might choose to go to small claims court instead, or your clients might choose to go to small claims court instead for these reasons. So, number one is efficiency. In the Greater Toronto Area, litigation, the courts are overbooked. Small claims court, though, is still the most efficient. Most claims can still be resolved within 1 year. Typically, the fastest you can do it, the settlement conference would be 3 months after you start your claim. Then the trial can be as short as 2 months after that. Whereas in Superior Court, which I'll talk about in a few minutes, they can go on almost indefinitely, depending on the schedule of the lawyers. Typically, it'll still be resolved under 2 years, but it can certainly extend to 2 years. That's not surprising at all. The cost of small claims court is lower. Some people find that they can represent themselves, or lawyers and paralegals that typically offer flat rates to go to small claims court as opposed to hourly rates, and you can save some cost. It's also lower risk. So in Ontario, anytime you sue somebody, there's a general principle that if you win your case, you should get some compensation for your legal costs. And in small claims court, that amount is capped at 15% of the value of your claim. So if your claim is worth $25,000 and you win your trial, you win your case, the court can award you a maximum of about $3,700 for the value of your claim, and so for the legal costs that you've expended. The problem with that, of course, is that that might not cover what you spent. It probably won't. You will probably have spent, if you used a lawyer or paralegal, at least $5,000 to go through trial, probably more. And of course, it's also discretionary. So if the court decides, okay, we're only going to award $1,000 in legal costs, there's nothing you can do about that. That's the court's discretion. So it's a cost-benefit analysis to whether or not you want to go to small claims court. That principle can also be an advantage because in the Superior Court, there's no such cap. So if you win your trial or you win your case, you can get compensated up around between 60 to 90% of your legal costs. And so that means, of course, if you lose your case, the person you sued can get compensated for 60 to 90% of their legal costs. And that can be easily in the tens of thousands of dollars. So if you could stay in small claims court, one advantage is that the worst case scenario, if you lose, the amount of costs awarded against you is capped. But again, that being said, if the value of your claim is relatively low, it might not be worth your time or your money to go to small claims court. So as I was talking about the Superior Court of Justice, that's the primary court in Ontario for real estate disputes. It deals with everything, all matters over $25,000. It has exclusive jurisdiction over claims for possession of land. If your client wants to claim, let's say the purchase fell through and they want to claim that house for specific performance, we call it, they have to go through the Superior Court. or if there's a boundary dispute, they have to go through the Superior Court. The Superior Court has a broad range. Yes.
Then that's the over 25,000.
Yeah.
The court has ended.
Yes. So if it's over $25,000, it has to go to the Superior Court of Justice, unless you waive your right to any payment over $25,000.
How about less?
Less, it goes to small claims court. Yeah. And also, even if it's a boundary dispute, but the boundary dispute, let's say it doesn't affect the value of the property very much. Let's say it's only worth $5,000. It doesn't matter. It still has to go to Superior Court. It is the only court that has authority to deal with possession issues regarding land. And so the court has a broad range of powers. It can put a lien on a property called a certificate of pending litigation. So if somebody's claiming an interest in a property, they can put a lien on the property. That's one of the reasons that is commonly appealed to for real estate disputes, residential real estate disputes. So the procedure, this was somewhat difficult because civil procedure you could take is a pretty thick volume, and this is just a typical procedure. There's lots of caveats, there's lots of complicated things that can happen in a civil litigation case. Again, things start with the pleadings. Those are the documents that are exchanged, the statement of claim, the statement of defense, the counterclaim, the countersuit. A few months after that, the parties have to exchange their documents. So the documents that they're relying on, the documents that say, this is, for example, if there was a failure to close, for example, the purchaser failed to find financing, they would have to disclose all relevant documents. So there's communications with their real estate agent, the agreement itself, any changes to that agreement, all the documents that could be relevant have to be presented to the other side. They have to be disclosed, and vice versa. So that would be, so if just for example, let's say a failed purchase transaction, it would be common for the real estate agent to get requested to disclose or file the contents of the file. Now, some of it, they might claim is confidential, but you have to disclose anything that could be relevant. So, what are the reasons for the failure to close? Anything that is related to that would have to be disclosed to the lawyer, and that's the responsibility of the person in the lawsuit to make sure that they disclose their documents. If they don't disclose the documents that they have available to them, they could be punished for it by the court. The court might not rely on their evidence. So after the documents are disclosed, there's an examination procedure. So people will come into a court reporter's office and they'll be questioned. And at that time, there'll also be a chance to request additional documentation. So for example, if let's say if the person being sued in a failed purchase transaction, if that person did not provide all the documents that one would think they would have, let's say, for example, communication between them and their agent, they can request that those documents be provided to them. This is the most common place for a case to settle. The reason for that being, this is the chance for both lawyers to assess their case. So they know the law, they know their legal arguments. If people, this is the first time they get to see the evidence, get to see the testimony. If they feel that the testimony went well for them, they might be more aggressive. If they feel it went poorly, they'll try harder to settle. So this is the most common place for cases to settle. If it doesn't, it's eventually set for a pre-trial conference with the judge. Again, the judge will try to encourage the parties to settle and give their opinion of what a good settlement maybe should be. and it would go to a trial ultimately if it can't be resolved. The trials in the Superior Court can be quite long. A small, typically 1 day or 2 days. A Superior Court trial can extend as however long is needed. Now, that being said, the vast majority of cases, over 90% of cases, don't go to trial. They get settled. The cost of civil litigation in the Superior Court is very high. Most lawyers charge an hourly rate in the hundreds of dollars, and it is very time consuming. So all these steps, all these elements, they can easily result in legal bills in the tens of thousands of dollars. And that's the main reason to resolve your disputes early and try your best to resolve them out of court. Again, as discussed, the legal costs can be compensated. So if you lose your case, you spent thousands of dollars fighting your case, and you lose it, now you have to spend thousands of dollars compensating the other side. So you have to be sure of what you're doing, and you have to be sure of the risks, and you should always be willing to settle to avoid that situation. Now there's because there's other processes that can be involved in the Superior Court to resolve real estate disputes. So, for example, if there's a dispute over the interpretation of the contract, the agreement of purchase and sale, the term in the contract, this can be dealt with by an application to the court. So the court can be applied to, and the parties can ask for an order interpreting the contract so that the contract can go ahead, so that the purchase or sale can close. Practically speaking, though, that's very difficult. These problems usually don't arise until near the last minute, and it's typically too late to get to court for the transaction to close. Typically, you need about a month or so to get into court before the transaction. There's also a step called the motion for summary judgment. So for more simple, straightforward cases, this is a way to fast forward the trial, fast forward the claim so that it can go right to a court order. This would be used in the real estate context for a simple, unconditional purchase contract that has failed to go through because of the failure to get financing on the part of the purchaser. The purchaser can't get financing, the deal fails to close, and it's a relatively straightforward case. They had a contract to buy the property, they failed to uphold that contract, and so because of that, they're liable for the damages suffered by the seller. And so the seller, they could lose value in their property, as you know. If it sells for less than what they had contracted for, they can claim that amount against the purchaser and for any other damages that they suffer. Bit of a misconception is that when you get your court order, either from small claims court or the Superior Court, that's the end of the story. Unfortunately, that's not the case. Even if you get your court order and it's not appealed, compliance with the court order is not automatic. The court does not have any authority to just automatically take payments or force payments from somebody. There's only a limited amount of tools that somebody has to try to collect payment from the person who owes them money. So possession of land, that's a little bit simpler. If somebody has to transfer the possession of title to them, the court can enforce that through writ of possession. That's very doable. It's more tricky with monetary damages. So if somebody owes, let's say you sued on your commission and the commission was unpaid, you got a judgment for that commission. What do you do to collect it? And so the court only gives you a limited amount of options. You can put a writ of seizure on sale on the property of the person. So they have to own real estate. If they own real estate, you can put a writ of seizure and sale of land on the property. So this would stay on the property as a lien. This is an execution. And you can also ask the court enforcement office to sell the property. So there's a procedure that has to be followed, but ultimately the property can be sold to satisfy the debt. The other option is a notice of garnishment. So if you have to know where they work, or if they have a bank account, for example. There's other items that you can garnish, but the key thing is you have to have some knowledge of where this person is receiving money from. So if you know their employer, you can garnish their wages, or if you know where they bank, you can garnish their bank account. The money can be taken out of their bank account. The problem is, though, however, if the person doesn't own any property, and you don't know where they work, or you don't know where they bank, then you're in trouble because you've got a court order for the payment and you don't know how to satisfy it. You can bring them in for an examination and you can ask them, there's a procedure for this, you can ask them questions about the assets that they own, the debts that they have. But if ultimately somebody doesn't have a great deal of liquid assets or property in their name, let's say all their properties held in the name of their spouse or their corporation or things like that. Corporation's a little different, but let's say, for example, things that are owned in the name of their spouse, then you might not be able to collect it because your court order is against them alone. And as long as the property was validly in the name of their spouse, you might not be able to collect it. That being said, you can't transfer property because your judgment is coming against you. If a court order is coming against you and you transfer title of the property to your spouse, that's a fraudulent conveyance because it's not for fair market value. The whole purpose of the transaction is just to avoid paying the person who's suing you. So that's a fraudulent conveyance. But if somebody is always validly owned title under one person's name, then that could be a problem. So that's a key consideration, again, because litigation is so expensive. You have to feel pretty sure that you can collect the debt, or else it's not worth your time or your money. So I just want to talk about a few residential real estate litigation disputes, common disputes that I see. So for defect cases, these are misrepresentation cases where somebody has misrepresented the state of the property. Either they filled out the seller property information statement or made some other verbal warranty to the person that, let's say, the structure is good or the septic system is working. And if the purchaser can show that the other person knew or ought to know about that problem, they can sue them. That's the key problem. It's all about the evidence. So if there's no evidence that the person knew about the problem with the property, then you don't have a case against them. So for your clients, you have to be careful if you're filling out a seller property information statement. I know in the Greater Toronto area, and that's probably for the best because it can result in litigation. For the agent as well, an agent can be held liable if they should have known about the misrepresentation. So, for example, if they were representing both sides and they didn't tell the buyer to get a home inspection when they should have known that there was something a bit fishy with the structure of the property, then they can be liable for that. For small defects in the property, Common problems. These are buyer beware. If it's something that can be noticed on like a cursory inspection of the property, the light fixture is out, or the blinds, things like that. Common problems have to be fixed before closing. If they're not fixed before closing, then there's no real claim against the seller, unless they did something, egregious. They said that they would fix it, but then they don't. But if it's simply just a matter of, something that the buyer should have noticed that they didn't notice, they didn't get a home inspection, then there's nothing that they can really do about that.
Question.
Yes.
If the defect has been fixed, then do the seller still disclose?
Okay, so the question is, if the defect's been fixed.
For example, the basement leakage, they fix it.
Yeah.
And then with warranty, so we still have to mention it.
They still have to disclose. Yeah, so that the case law on that is a bit inconsistent. Generally speaking, sometimes the court will say it's about being reasonable. So my understanding is that if it's been a long time and there hasn't been an issue in years, there's no real reason to disclose it. But I would say that to be safe, let's say it was a recent issue, then it would probably be better off disclosing it, because if you didn't, then that would be, it would certainly result in litigation. Whether or not it'd be successful would depend on the facts. But if there was a flood beforehand, and then let's say there's a flood shortly after, like a leak shortly after, that person's probably going to get sued, because if the buyer finds out that there was a problem before the deal closed, that person will probably get sued. So if it's a recent issue, it's probably better to disclose it. Yeah.
I mean, if the flooding before, so the disclosure, how about now it's fixed now? So
Yeah.
they have to disclose
If it's
the
fixed,
flooding
if it's
before.
fixed, I would still say if it's a recent issue, you're probably better off disclosing it, because that way they can't get sued for it.
What is the reason?
I would say, like, it's a judgment call, but I would say anything within the last, several months before the closing. Because if the buyer finds out after the fact, if they find out after closing, then they'll probably sue. It's just a matter of avoiding the litigation. I would generally say, yeah, but if it's, let's say it's been 2 years and there's been no issue, it's been fully resolved, then I don't think there's an obligation. But each case is different.
Yeah, but this is sometimes it's common, like some was leaking, ceiling leaking, or so they fix it.
It depends
But
on
they just
on severity of the issue as well, right? So if it's just a very minor issue, then there's no real need to disclose. But if it's a significant flood that caused this person damages within the last, let's say the 2 months before the closing, you're probably better off disclosing it, because there's no harm in disclosing it. The purchaser might ask for, let's say, some sort of abatement, but there's no real reason to give it if the issue's been resolved. The key thing about the disclosure is that the person bought the house anyways. The liability comes from the knowledge, it comes from misrepresenting the issue to the purchaser. Let's say though that the purchaser, there was never any representations about that, then you're probably still okay. But I would say overall, the safest to disclose anything that could pop up again that's recently, because if it's disclosed to the purchasers and they buy it anyways, they can't sue for it, because they had their chance, they had the knowledge that they needed at the time, and they still chose to buy it anyways. But that's just my opinion.
So somebody said that after the house is 10 years old, just half year they bought from builder, then house builder keep. So then the builder already fixed from these 10 years from
Yeah, that would be different.
So
That would be different. Yeah, that would be different, because that's a very long time ago, and so there's no issue. It's just about these tricky little cases where it's close to the closing date, where it's not disclosed. Even if it's not like the sellers are doing anything wrong. Like in my experience, the sellers could have fixed it perfectly, but because a problem showed up shortly after closing, they still got sued. And so that's just the problem that can be avoided if it's disclosed before closing. For deals that fail to close, either the purchaser or for the seller, the most common reason unconditional purchase and financing fails to come through. Again, for this to be resolved through the real estate agents and the lawyers, but if it's not, then litigation is likely to be started. The agent's role in this type of situation is to speak to a couple of matters. For one, when a property fails to close, the person property has to still try to sell the property for the best price. So they can't rely exclusively on the purchaser and the first purchaser to try to cover all the damages. The court won't necessarily award the same amount that they lost. The person still has to show that they tried their best to sell the property for the best price. So the role of the agent might be to act as a witness or to give some evidence to show that the property was still sold for the best price that was available at that time. I mean, it's not uncommon for a property sold for a lower amount, let's say after the summer. Let's say the original deal was for the summer, and then the second deal had to happen in the fall. It's okay because that's just the nature of the market. But the agent might have to give some evidence as to why that's the case. The other issue is on the purchaser side, if they want that specific property, I mean, they can claim for damages if the seller fails to close. But if they still want that particular property, they have to show that there's some uniqueness to that property. So the agent might be required to give some evidence about why that particular property is particularly suited to the needs of that purchaser. And as well, so for these, for your commissions, it's a good thing that it's rare that a commission fails to get signed. Sometimes it can happen that the listing agreement has a holdover period and the person buys it during the holdover period to somebody that you introduced them to. Generally, to monitor that period, if somebody has purchased the property that you introduced them to, you should be able to get compensation for that. Get some legal advice. Every case is different. Get some legal advice. You might have a claim. Generally speaking, always get your agreement signed, especially for buyer representation agreements. Sometimes you can do work for a buyer without them signing the buyer representation agreement. You have to be careful because they could be taking advantage of you. It's always best to have the agreement signed. That way, both of you understand what your rights and responsibilities are. I'd also say that to document your work, just make sure that everything you've done. And it's also a good idea to obtain the employment and address information for your clients. That way, if something goes wrong, you can find them, you know where they work. That can help in the collection if it ever comes to that.
One question.
Yes.
How often you see the sellers before introduced to close?
Seller refused to close? Not often. Not often. It has to be a
99%.
Yeah, 99% buy. It's very, very rare that the seller refuses to close. Typically, it's because there's a dispute along the way about maybe the interpretation of something. Maybe there's a title issue, and the seller feels like the title issue allows them to cancel the contract, but then maybe later on the court decides otherwise. But no, it's much more rare. Yes.
So, okay, so selling a house, so the husband is in charge, the wife is not in charge. So the just say document by husband. So how I can verify his wife, who's his wife? And he said, okay, the offer condition is going to be tomorrow. And he said he's going to ask his wife to sign after that. So how I can know who's his wife? He can ask anyone to sign.
You can ask him for like his marriage contract or something like that, his marriage license, just to prove that they're spouses. But we can talk about this after the session. Okay, and so for again, so for these kind of real estate disputes, a lot of times I find even if it's not the agent's fault, the agent will get involved. The person might still blame the agent. That's why I suggest, especially for difficult clients, keep your work documented. If you give advice to them, or if you're discussing financing. So when, especially for these unconditional agreements, that financing is not a condition for the purchase. Make sure that they sign off on all of the important points. If you give them advice, do it in writing. That way you can assist whoever's representing you or your company through your insurance. You can assist them by making sure that they don't have any claim. And so for these negligence claims, they're all based on the standard of care of the real estate agent community. So just always maintain your best practices of the community. And if you're uncertain, you can get legal advice in uncertain situations. That's all I have. Thank you. So if you have any questions, you can open now, but it's almost. Should we deal with the questions on camera? Or if there's specific questions, I'd rather deal with them off camera. So, yeah.
Yeah, what question I asked, you say it's and your address.
Yeah, so we'll talk about it. Yes. Yes. Yes.